not one
news in his life. A spouse was sick. A tree fell on his house last night with some of the strong overnight weather that we had. And he wanted to be dismissed and has been, and that has certainly given us a 10 to a 15-minute break here. So we are ready, as you are looking at Andrea Sneiderman right now, flanked by her defense team, headed by J. Tom Morgan there, not wearing a bow tie today as he was yesterday. And I am here with Bill McKinney. A reminder, you are watching 11 Alive coverage of the trial of Andrea Sneiderman, and this is the day, the final jury selection of 12 and 3 alternates from a pool now of 41. So into the courtroom we go.
Just a second.
Yeah, there's one over here in the box. All right, here at the countdown is now in session. Under Judge Ray Adams presiding. All right, good afternoon. You may be seated. All right, good afternoon, ladies and gentlemen. Thank you very much for your patience. We are at the point now in which the state of Georgia and the defense, in the case of State vs. Andrea Sneiderman, are ready to proceed with the actual jury selection. Ladies and gentlemen, I fully understand that we had come to this building about 6 days ago and completed a questionnaire, and now it has brought us to this point. Both the state and defense will have an opportunity to review a proposed list with jury management and make their selection. I will direct the clerk at this point in time to begin the process. You may actually put them in the list.
You want to maybe move our chairs around?
You may if you wish. And lawyers, both sides, you can move the chair, get yourself appropriately. Ladies and gentlemen, what's going to take place, they will alternate a proposed list between the state and defense and make their determination on the list. And this is what is done by what is called silent strikes, which means the lawyers will be talking to you at this point in time. The only voice you probably going to hear is mine from time to time. And I'm not going to talk during the entire process, but I will just talk about some general things while they're getting themselves in position. Now, you are seated in the jury box and also seated there in the gallery, and they will look around and make their determination. All of this will be done silently until we get to the end, in which those particular prospective jurors will be identified. And when I ask Jay with jury management to begin the process, what is taking place, you will alternate the proposed list between the state's table and the defense table, and they will be making their determination silently. This actually is an improvement of the old system. I mean, many years ago, what would take place, the jury clerk would call you by number, and you would stand in the jury box, and either the state or defense would either accept or excuse that juror. But what would happen is, when people were hearing that they were excused, they took it personal, as if they were being released or something. But no, the same process is taking place. The lawyers are making their determination, but it's just done on paper. Either they will accept a potential juror or excuse a particular juror, but it is done silently. And during this time, as I said, while they're alternating the proposed list, I just want to take this time again to thank each and every one of you for setting aside your favors, coming in and participating in this process. The way this process has taken place is how juries are selected all over the United States each and every day. The day is Thursday, and obviously this process actually started on Friday. But I do publicly want to commend the lawyers, all 8 lawyers who are involved in this particular matter. They have actually done a very good job of moving this process along in a very swift and conscientious manner to allow us to get to this point. And I know sometimes when I'm after talking to juries, sometimes they feel the lawyers are going through and giving them quote unquote the third degree when they're asking questions. But actually, the lawyers, by asking questions, that's the only way they can find out anything about you at that point in time. Although we did in this particular case use written questionnaires, but they were allowed to follow up those written questionnaires with questions. But this is normally the first time the lawyers would have had an opportunity to interact with you, and because you had no, for the most part, no previous relationship with any of the lawyers who were involved in this particular case. And it is always important, in order for the court system to operate, whether it is a civil case or a criminal case, for potential jurors to come into this courtroom with an open mind, set aside any issues they may have, and be willing to listen to the evidence as it comes from the witness stand in the form of sworn testimony and any physical evidence that's introduced in the course of the trial, and listen to the instruction from the court and base their decision upon that. And again, I do want to thank each and every one of you for setting aside your favors and coming in and participating in this process. Now, the way it will work, and it's going to take a little while longer for them to go through that process, and I'm just giving some background information at this time. Sometimes, and I just, as a way of instruction, I will have to take up matters outside of your presence, and during the course of the actual trial, now we did it earlier during the course of jury selection, I will turn on that background noise and turn off various microphones and allow the lawyers to approach so we can have a off-the-record conversation. And I don't want you to draw any inferences from that one way or the other, because sometimes I just need to talk to the lawyers need to confer with me about some issue prior to being quote-unquote on the record, but don't draw any inferences, don't draw any conclusions from that one way or the other. We're just talking, all right? And also, I know sometimes because of the smallness of the courtroom, I will put up a piece of paper to block the view of the particular jurors, because sometimes people are just curious. They want to know what is the judge telling them, and they try to read my lips. So I'm putting that up not to be disrespectful to you, so I don't want you to draw any inferences that I'm trying not to look at you. It's just that people do that. I've been doing this for long enough to know people, they look around, want to see, well, what is he saying, and try to read my lips, and some people have that ability. And that's the only reason that's done. Also, you notice throughout this process, the lawyers have referred to you by numbers. And don't take offense to that. That's something I had instituted in this courtroom several years ago after interacting with jurors, just to have some level of protection of your privacy and intimacy. Because sometimes, and even in this trial, people have to always answer truthfully, but sometimes you may have to reveal some information about yourself that most times people don't know. I've been in this very same courtroom and people reveal things that they later reveal here in open court that they had not revealed to their spouse. And because of this case and others, when you're saying things in a public forum, I just want to give you some level of privacy because you were invited here as a free citizen, and that's one of the reasons for that. They refer to you by your numbers to give you some level of protection. And for the practical purposes, your name has yet been used in a public forum, so even those of you who are not selected for the jury, when you are dismissed later today and you've gone about your business, you still have complete anonymity if you wish. And matter of fact, people walk out the door with you, they don't know your name either unless you tell them. But that is completely on you. I put the responsibility on you on if and when you want to reveal your identity to others, but just so that you can have some level of privacy. And for the most part, when people look around the room, they did not recognize almost anyone in the potential jury panel, which is a good thing, because we don't want individuals in a position in which they feel as if someone has revealed they have to reveal some sort of information. You might come on up, lawyers.
You're back with 11 Alive's coverage of the Sneiderman trial, joined by attorney Bill Kenny. Bill, what's going on here?
Well, what usually happens at this stage is that there are going to be two alternates, and there's some confusion as to where the cutoff is for the alternates. So they're probably up there saying, Judge, where are the alternates? Because they're each going to have a strike on the alternates too. The other issue might be that they have somebody on there that they forgot to say we'd like to strike for cause, and we forgot to. So this is what's going on now. There's something in the process where there may have been an error or they want clarification, as to where, because they're going to pick the first group and then they have two alternates, and they may not know where that cutoff is because the alternates are additional strikes.
I think for some people watching, we have seen the infusion of a new face, the woman in purple who has been in between the two sides. What is her role in all of this?
She is probably the jury clerk. She handles the jury. And she is taking what we refer to as the paddle, because in the old days they used to call it that. But that's the piece of paper we've seen go back and forth as each side would strike one of the jurors. They don't want, the person is unacceptable. And what happens sometimes is you might have a list of 10 or 12 people you want to strike, and the other side strikes them. Well, that gives you more strikes, so you have to go further down on your list of people you may feel that would be unfavorable or biased. So it took a little while, but they went through it very quickly, I think, for this type of jury selection. But maybe we'll see what the judge says now. Maybe we'll get an indication what happened.
I'm taking a look at our own Julie Wolf, who is tweeting from inside the courtroom. She says, I am spying a juror sleeping. She just jerked awake when the judge put the noise machine on. Nope, back to sleep now. Sometimes jurors just have enough.
That is one of those times, ladies and gentlemen.
That's true. And sometimes that's a neutral. If that person's not going to hurt either side, sometimes you leave that person. You go with 11-person jury because they're going to miss half the trial.
All right, let's go back into the courtroom right now.
Because that happens. And also, just as a way of background, for those of you who are actually identified and actually put on the actual jury, although I anticipate that I will conclude this portion of the jury selection process today, I will have those individuals report back on Monday to actually start with what is called opening statements and the other things I outlined to you. And I will give you instructions at the conclusion of the day. You're going to hear what I've said over and over, but I will say it again, just so that you will hear it. When I do release and the jury is actually selected and give you instructions reporting back on Monday for opening statements, I'm going to tell those people who are in panel with us not to discuss the case or allow anyone to discuss the case with you while I'm waiting for the lawyers to make their determination, and that simply means what it says. Obviously, you have spouses, you work for someone, you may work for yourself. You can tell those individuals that you have been selected to serve on the jury, but I don't want you to go into any details because I don't want you to formulate any opinions about anything at this point in time. I always want you to keep an open mind. When we get to that point of dismissal, I will allow you to leave the floor. And as I indicated, I may not have been as clear as I needed to be. You will not be sequestered, which means you will not be spending the night with us. We're going to be able to leave and go home each and every day. We're going to stop at a reasonable time, and reasonableness will be defined by me on a daily basis. So I want to ask you what time it is. But that's all I'm going to tell you for right now. But it's for a reason. I will factor in all those things that you have told me over the last, I guess, 5 days, including the jury selection, on your schedules. But I will normally factor in times that you have to provide care for your children, your significant others, your loved ones, parents, and all those things will be factored in. But I will give you that information on a regular basis. Also, as I indicated, and you're going to hear it again, but I cannot emphasize this more than enough, those of you who are actually selected for this particular case, not to read any media coverage pertaining to this case. If you receive any type of newspaper at your home, I'm going to ask you, this is all based on your honor system, your own integrity. You're going to have to store those newspapers until you are finished with this process and read them later. I'm going to direct you, as you've heard me say before, do not go upon the internet and do any research about this case. Do not blog about this case while it's ongoing. Do not text about this case. Do not converse about this case. There will be a time in which you will gather in the jury room and you'll be able to talk about the case and review the evidence and listen to the law. But for right now, we're not there yet. And so that's about as best I can do when I say don't discuss the case. I'll allow anyone to discuss the case with you. I fully understand today's Thursday. And for those of you who are selected, we won't be together on Friday, Saturday, or Sunday. We won't be back together till Monday. You're going to be out and about carrying your normal life. And as I mentioned to you earlier about when you go out to the restaurants and things of that nature, don't sit next to anyone who may be discussing things. I mean, that's just part of it. You're going to have to move away from someone. I'll ask them to move away from you. But don't let someone sit next to you talk like that. Because I don't want you to engage in a conversation, and I don't want anyone reporting to me later that, oh, I was at the, I'm going to use it as an example, the beauty salon or the hair salon or the barbershop, and that person who I think may be a jury in the case judge, they'll sit there and express some opinion on this Saturday or Sunday or Friday about the case. Because that's not going to happen because all of you are high. High individuals who at least I believe are high integrity, and you're going to follow the instructions I provide. And if you're at a, I'm just using that as an example, at a beauty salon or a barber shop in a discussion, you're going to have to get your hair cut somewhere else or get your hair done somewhere else. Until, I'm not saying you can't do it somewhere, but you won't be able to do it where that conversation takes place. So you may have to ask your, I think the term is stylist, to give you a private room. So you won't be around talking to you. And that's about the best I can say. I mean, that's just an example. I can't think of every scenario where you're going to be in. If you're riding in the car with your spouse or significant other, you won't be talking about in the car about this case at that point in time. It's, like I said, it is based on your own individual integrity because, as I have given you these instructions before, even this time, not to discuss the case or allow anyone to discuss the case with you. All I can do is try to anticipate some of the scenarios, and those are at least 2 examples that I may give. If you're standing in the grocery line buying groceries and somebody behind you, for whatever reason, is talking about this matter, you're going to have to do 1 or 2 things. Let them go in front of you and go buy something else, or tell them, don't talk about that around me. You don't have to tell them why. Because I don't want you to be put in a compromised position on any level. And those are just a couple of examples. I'm not going to give you all the examples. I'm not going to talk the entire time and fill up this time while they're doing jury selection. But I could talk that long if I need to. So if you, at some point, you may get tired of hearing my voice, which is okay. I don't take it personal. You will be allowed to bring something to snack in or eat with you during the time in which you're with us. Just to let you know, this is like I said, this is background. We will provide those individuals with coffee on a daily basis and also all throughout the day. And I will just tell you which coffee we provide, Maxwell House. And I can tell you, and I'm just telling you that in advance, and it's good to the last drop, I can tell. We will provide you the sugar and the cream, and it's a non-dairy cream. And in the jury room, there's a miniature refrigerator, so if you need to bring medicine or anything that needs to be refrigerated or your own lunch, that is there for your availability. Or if you want liquid cream, you can bring your own can of cream, keep it in there, we will provide you with Maxwell House coffee. And only people send out, and it will have caffeine in it. I do not provide decaf, so sometimes people make those particular requests. I'm just letting you know that in advance. It will be Maxwell House coffee. It does have caffeine, and we will provide you with water. Also, because of the way we operate here, it'll be a very tight schedule. All your breaks can be taken there in the jury room, so we will provide you something to snack on during the breaks, and we provide you with animal crackers. And I know some of you may not have eaten animal crackers since you were a child, which is fine, but I just tell you in advance, you don't have to eat them, but they will be provided for you, and they are low in fat, and we will provide that to you. You will be able to bring, if you want to bring something other than Maxwell House coffee, you want to bring Coca-Cola, Pepsi-Cola, whatever drink, or whatever you want, you can drink a beverage there in a jury box. You will not be able to eat in a jury box, but you can bring a drink or a beverage with you of your choice. Non-alcoholic, and there in the jury box. You will not be able to consume any alcohol during the course of the trial, during the daytime. And I will tell you at the appropriate time, you cannot overindulge in the evening. I just have to keep you focused and attentive while you are here with us. Also, those of you who are in the jury room, when you're in the jury room at various times, and I will tell you this each and every time, but do not come out of the jury room and wander up and down the hall. Do not leave the jury room unless you are escorted by either a bailiff or the deputy sheriff. But at all times, someone will come and retrieve you when it's time for you to come back. Although I may use the term, and the breaks you're going to find pretty tight. The breaks are going to be defined in minutes. And I may say you may have an 8-minute break, 9-minute break, 10-minute break. And you're going to find over the time in which you interact in this courtroom, that time is real. 10 minutes means just what it said. And you're going to find that's real. And those breaks are designed for you to do just that, take a break. I will factor in some extra time based upon the volume of people, because when you go into the jury room, there are 2 restrooms there, one ladies, one men. They're technically unisex, and you just close the door and do what you got to do. But the point is, a break is designed, is just a break to keep the trial moving in a timely and professional manner. And the lawyers have been put on notice about that also, so that would not be a problem. When I give you a time to report back, it will be a definite time certain. And the reason I mention that because I will have to wait until you assemble before we can start this process. And I can't finish a day of testimony until we start a day of testimony. And that's just a nice way of saying I need you to be on time. And I fully understand sometimes people are time challenged, and I understand that. I know someone mentioned to me not too long ago, why did I have such a large clock on the wall? That is not, it's the one right behind you in the jury room. That is not necessarily for my benefit to know what time it is. It's just that time is very important. I cannot make it for lost time. So when you come in and you see that clock, that means something. So when I ask you to be here at 9 o'clock, and we actually start at 9 o'clock, if it's not 9 o'clock on that clock, that means we didn't get started because somebody was late. And it's just to remind you each and every day, being on time is important. Obviously, I cannot anticipate the weather, but I do know if you are here in Metro Atlanta, anytime it rains, things of that nature, there are more cars on the street, but you have to factor that in. And on the badges that you will be provided, those you select for the jury, my office number is on the back side of that badge, and obviously in case of emergency, feel free to call us. But I prefer for you not to call me every day telling me you're running late. My question is for you, my admin is designed for an emergency. Also, when you come into the building, yes, you will have to come to the metal detector. Yes, you will have to ride the elevator. Yes, you will have to park in the parking garage. But the reason I mention those, it sounds very basic and routine, but you have to factor in all that time so that you can be on time. So I have no idea how long it takes you to park your car, turn it off, walk into the building, go through the metal detector, wait for an elevator, come up, because you don't have exclusive right to the elevator, so others will be riding, but you have to factor in enough time, no matter where you're leaving from, so that you can still, quote unquote, be on this floor, which is the 5th floor of the DeKalb County Courthouse, on time. And I just mention that because I have to wait till everyone's gathered in order for us to start our day. But sometimes, because if our day doesn't get started quite on time, it may put me in a position where I may have to extend our day. And I don't want to extend our day because I don't want you to slip in the note saying, Judge, it's 9 o'clock at night, I need to go home. Because we got started late, because I couldn't get started late till everyone's here. So the point is, I normally answer, I didn't ask this particular panel because we did a little differently, on interview time challenge, and I should have asked that early on. Time challenge means you don't know how to be on time. And that's simply what it means. If you're not time challenged, the expectation when I ask you to be on time, I need you to do everything that's humanly possible to be here on time. That's all. And that'll be each and every day in which we are convening for court. Also, during the course of the trial, the deputy will provide you with a writing pad and a writing instrument. You're more than welcome, those who select for the jury, you're more than welcome to take notes. They're completely up to you. But your notes are for your use each and every day, whatever notes you take, and we have more pads than you can use. So if you run out of one pad, we'll give you another. If you run out of that pad, we'll give you another. Your pencil breaks, we'll give you another one. So at any time, if you use your pencil breaks or your pad has exhausted, let the deputy know or get my attention. Or if you cannot hear or see something, I'm not talking once I'm looking at them, but if anybody who's on the actual jury, raise your notepad and get my attention, and I will stop what we're doing, because it's important for you as a juror to hear and see everything. So if you can't hear it, you won't be able to use it later, but you need to be able to hear it and see it. So, but I don't know that unless you communicate with me. You won't be yelling out. You just get my notation, as I indicated earlier. Get my attention, I should say. Because as I indicated earlier, any communication from you as jurors, once you are selected, we get to that point soon, it'll be reduced to writing, given to the bailiff, and he or she will bring that out to me, and you will wait until I can give you a response. So, but there'll be no live interaction. It'll just be in written format. And if you could, print clearly so that I can read what you write, if you don't mind. It just helps me, so I won't have to try to interpret the words. Also, at the appropriate time, I will ask you, although you can take as many notes as you wish, nobody's going to look at your notes but you, but I'm going to ask you to leave your notepads there in the jury room, just turn them face down, and the only reason for that is that it's easier to keep track of those for you. You're going to tell you, put your name on it, your pad, turn it face down, nobody's going to go in and look at it. It's just that when you come back the next day, they're there. Because if I don't do it that way, what you think may happen? You aren't going to answer, I'm going to give you an answer. Somebody's going to leave a pad at home, and they're going to say, Judge, I didn't go home and get my pad. That's the only reason I do it that way. Everything, there's a method to the, this is my term, method to the madness. I'm just using that as a term that I'm using. So everything has a reason. It's not just made up rules and processes just for the sake of having that done. For another term, this is not my term. This is not my first time at the rodeo. And so we're doing this for a reason. All right. But those badges that my deputy will provide to you, you will be able to carry those home with you each and every night. And my direction to you will to wear those badges prominently on your clothing at all times while you're in the courthouse. Because that way the deputies and the staff and individuals will know pretty readily, seeing you from a distance, that A, you are on the jury, and it will identify you as being a juror here in Division 5. And as indicated, it will have the office number on the back side of that particular badge, so that if an emergency takes place, you will be able to contact the office. You can call that number 24 days, 7 days a week. It will go to a voicemail, but it will be checked at a reasonable time throughout the day. Also, because this process is, those of you who are actually selected to serve on the jury, you would not be able to carry any communication device there into the jury room. So your cell phones, laptops, pagers, if anybody has a pager, iPhones, any type of communication device will be collected up from you each and every day and turned back over to you either at the lunch break or at the end of the day so you can check your messages. But you will not be able to have any communication, any electronic communication device with you in the jury room, okay? And for those who do, sometimes people, bless you, because sometimes people leave those individuals in the car so that they can just check them at the break in the car because they don't want, which is, you can leave them in the car or leave them somewhere else, but you'll be able to check them, but you won't be able to have them in the jury room, any type of electronic device that will communicate outside, okay? So that will not be collected up front of you. If an oversight takes place and it gets by one of my deputies and it's in there, just bring it back out and let us know, here's my phone. Also, my request, do not put it on vibrate, but put it in off. And the reason I'm asking that, because if it's on vibrate, I will have a number of telephones buzzing all throughout the day, and it becomes a distraction. So I don't want you listening to, is that my dial tone over there? I want you to listen to what the witnesses are testifying to, so you focus on the trial. That's one of the reasons too. So you can stay focused, not worry about your dial tone, because everybody could have, a lot of people, I've been around, a lot of people have creative dial tones. And we've had to go off over there in the box that we hold them, and then because some of them are very creative. And so as a result, it becomes a distraction. So my request is, you can bring your devices, put it in the off position, not in vibrate, please. So, logistically, those are some of the things that we will provide you with. Also, as far as any time that I give you to report back here, at least my slogan is you can be early, but you can't be late. You know, no matter what time you start, you can come to the courthouse early, because we can accommodate you being early. So you can always come a little bit early, no matter what time I give you, but if you could, do everything you can not to be late, if possible. Obviously, I know emergencies happen, but hopefully they don't happen every day. It will cause you to be late or delayed in coming into this courtroom. Again, as I indicated, I want to thank each and every one of you for taking the time to set aside your affairs and participate in this process. The court systems could not work. And actually, I think it is one of the highest honors to be serving as a juror in your community. It doesn't get any better than this. This is the court system. Lawyers, come up.
Welcome back to 11 Alive's coverage of the Sneiderman trial. I'm Jeff Hellinger along with attorney Bill McKinney. And here we are again with both sides in front of Judge Gregory Adams, who told the prospective jurors looking at a sleeping juror, he said he is going to provide everyone with coffee and it is going to be Maxwell House. It will not be decaf. He also told the jurors that you probably have not eaten animal crackers since you were a child, but that's what you are going to be served during breaks. Some of the information that probably will not be part of this trial that we will be knowing a lot about, but it's curious to watch the inner workings of it today.
What's interesting is during trials, when jurors go to sleep, defense counsel and prosecution runs the risk of going up and tattling because the other jurors see that. So what you do is you slam a book down or you're extra loud in some way, and that will wake up normally the juror unless the juror is really sleeping. Then you have to go to the judge. But the other jurors know what you're doing. So if you go up and tell the judge something, the judge then makes an example, the jury then sometimes will not like you for doing that. So you usually slam a book or make some noise to wake that person up.
I would be remiss if I did not ask you, given all the things that we have talked about this afternoon, is there an advantage for the prosecution or the defense with a sleeping juror?
No, a sleeping juror on the prosecution side, if that person starts to sleep on their, because they go first, they have the burden of proof, let them sleep if you're defense counsel, and let them snore, get them a pillow, because they're not hearing the evidence. But on defense side, when you start to present your evidence, you want every one of them to be alert, understand it, hear it, see it. So to answer your question is it's a detriment to either side, and you have to be very aware of what the jury's doing.
I've been following some of the events from other reporters as far as their tweets. One was talking about a silent strike for the jury. Would you explain that to our viewers?
Sure. The normal procedure at this point will be when the attorneys go back, they will then have each juror stand up, and then either side will say accept or reject. If either side rejects that juror, they are excluded. And that's done throughout the whole array until you get your jury. Now, if it's a silent strike, it could be that the judge is going to just announce the jury. He's just going to simply say, look, we're not going to go back and forth. You did your paperwork. I have the jurors here. And he will announce those jurors and put them in the box, put them in the jury box. And then the jury won't know really who's accepting and who's rejecting.
These sorts of rules of engagement today are very different from what they were over the course of the last 3 days, aren't they?
Yes, they appear to be. And again, I think you're seeing cooperation among the attorneys in this case to get this thing moving pretty quickly.
And we are going to go back right now. They are breaking and coming back to the table, and we will continue back into the courtroom.
All right, we're back on the record. The lawyers will continue that process. And as I indicated, ladies and gentlemen, this is what's called a silent strike. Instead of me giving you what I call some of this background information, we could be sitting in total silence. And by this time, you may prefer total silence. But that's what's taking place. It's done by a silent strike. I was just utilizing this time period to give some information and some what I call instructions for those individuals who will actually remain with us on the actual jury panel. However, in a lot of what you heard during quote-unquote this silent strike process, you will hear it again so that I can emphasize it. And I know sometimes it may appear that what I'm saying is, what's the word, redundant, which is okay. I know the other day I was having the jurors report back, and I said as many times as I could, report back at 1:30, and they thought I said 1:45. I I said 1:30, 1:30. That's okay. That was a communication. They thought I said 1:45. Although I said 1:30 as many times as I could.
May we approach?
Come on up, Lori. Yes, sir. Lori.
Back with 11 Alive's coverage of the Sneiderman trial. I'm Jeff Hellinger with attorney Bill McKenney. You are looking at the live feed from the courtroom right now, and that is Andrea Sneiderman, who has been making a lot of notes this week, a copious amount of notes that she has taken. Will these notes be used by her defense attorneys, or is that pretty much to keep her occupied and something to do through all of this?
You have to have the input of your client. It's basically unethical to just simply pick a jury without her input. It looks to me like she's got the jury list, those that they are either choose on, and they say, I didn't have a chance, I didn't want that juror. So what they're doing now is giving her, I think, a chance to look at the proposed jury that they've selected and have her input.
You just have to be present because what takes place when they're going through the process, because there's so many people, they can look around and make sure the numbers are consistent and everything with their notes. So it's not a problem. Just wait on the go. As I say, I commend the lawyers. They're doing a great job. I mean, I've been here doing this a lot more days than this, so this is good. Today's only Thursday, and this is wonderful. We're at this point. Yes, sir.
Yeah, may I
No, come on, Lord. No, come on, Lord. We're here. Come on, Lord, please.
Our 11 Alive coverage of the Sneiderman trial continues. Again, we have the attorneys back in front of Judge Adams, and this has been very different today. This has been a lot of the sort of small parleys, there seems to be more intrigue today. It's been more difficult for us to follow as viewers of this than over the course of the last few days, where you've had a lot of dialogue between prospective jurors, the judge, the attorneys. There has been a sort of banter, a public banter that has gone on and on. Today, not so much that. There has been sort of a go and then stop, go and stop, and then a lot of it has been this sort of private discussions in front of the judge.
I think a lot of it, number one, if you look to your left, you're going to see that the jury is still there. If they're talking about any technical issues or the proper procedure to choose a jury, you don't want the jury to hear that. You want them to be pure. You don't want them to be affected by whatever the attorneys are saying there. So this is normal. The bench conference is normal. Normally the judge will have a little button where he can put static up so you can't hear it. So this is all normal, but you're getting very close to when they are going to have the jury selected, and this is the last minute. Make sure you have your alternates, where you're going to choose them from. If you have any strikes or have any objections at this point, let us know. And so now they're going to go back. I think they're going to pick a jury.
You do? You think they're going to be all set here very shortly?
I do.
Okay. Back to the courtroom.
Oh, I mentioned, ladies and gentlemen, because I know sometimes, especially if you're sitting on the wooden benches, that wood becomes firm after a while. So if you want to stand, I can't let you leave right now, but if you want to stand where you are and just stand and stretch, it's okay. You can do that. And also, if it gets to the point somebody needs a restroom break, which is okay, just raise your hand, let me know. And if one person needs one, everybody gets one. I'm not going to force it on you, but because like I said, I was just talking while they were making this selection, which is not a problem. Because everybody, this is my term, is on a different schedule, which is okay. But I know the individuals who are seated to, this is my right, your left on that side, those seats are a lot more comfortable because we have padding there, and they may or may not recline. I think I never said them, but I'm assuming they recline a little bit. Like I said, I never had the opportunity to do that, so I'm just assuming they are soft and comfortable. They look soft and comfortable for here. And therefore those individuals who are seated to my right have a little bit more comfortable of a seat. But for right now, you just have to be with me. There you go, 6th is taking advantage of what I just said. If you need to stand and stretch, it is wonderful. It is not, I just can't let you leave the room right now. However, if and when someone gets my attention indicated that they need you can do it like this way, break, and that means, which is okay. And I'll take responsibility for taking a break, and I'll give you an opportunity to go out collectively. Because right now, we're going to have to keep everybody together just for lack of a better term, management of people. So I know you're all individual thinkers, and normally you can do things on your own, but right now, we got to do it as a group, just for right now. And I appreciate your patience, your understanding, not drawing any emphasis from that one way or the other.
Yeah, if I could just bring to the court's attention, we need not address any more of the matter that we brought to the court's attention a few minutes ago. We're satisfied with the procedure.
Okay, that's fine. Thank you very much, Mr. Speaker. But as I said, ladies and gentlemen, feel free to stand, stretch. If you need to, it's where you are. I just can't let you go right now. It's just that when the building was designed, and I know sometimes cloth and padding is put on benches, but in order for, this is my term, to save a little money, there was no cloth or padding put on the benches. Because I know you can go different places, churches, synagogues, funeral homes, and the benches have padding. But here we decided not to, and just to save money. But as a result, as time goes on, the wood does not give way. And as a result, it's firm, and it gets firmer as time goes on. So, but that's just the way we are structured right now. And for whatever reason, it's getting a little warm in here. I didn't turn the air conditioner off, but that happens sometimes. This building, it breaks. But we will make a request at the appropriate time to have the air conditioner on. But it happens. We're still inside. You good now? That's fine. No, we're good. No, that's fine. No, you can stay. Yeah, you can't talk. You can't really talk. Like, you can stand and stretch, but don't. No, you can stand. If you want to stand and stretch, that's fine. It's just that we can't have, we aren't having group discussion right now. And I know, I tried for a minute. I just stopped talking to see what your reaction was going to be. and you start moving, which is okay. I have no problem with talking and filling in this time. Matter of fact, if need be, I'll talk for another 3 hours. But no, I just use that as a time of estimate. It's just that I was always thought I had to, and I don't mind talking, and I don't mind actually hearing my own voice. So it is okay. But I was just using that to pass the time. So because when it gets quiet, it's just quiet. You can hear a pin drop, and with that, it seems as if time is running a lot longer or slower than what it. But actually, time runs at the same time, whether I'm talking or not. And we will, but it does sound like it's getting a little warmer. The air is not circulating as much as it should. It's fine. And I appreciate your patience, your understanding. But this kind of process works all the time. Jurors come in, they sit, lawyers look at the list back and forth, but they are doing a wonderful job because, as I said, I thought I wouldn't get to this point until tomorrow. So as I said, we are a day ahead of schedule. So this is wonderful. It's almost use the term of blessing, but I don't know if I can use that term. It's very good, very good. Because today is Thursday, it is early. So it is not, and everything is relative, and I fully understand that. And as I indicated earlier, after the jury has been selected and those individuals will be given certain instructions, and the ones who are not selected will be released. We're not there yet, but we will be there fairly soon. And actually, it will, be like to complete your service. And as you know, here in DeKalb County, we have over 700,000 residents. And the way the system works on the jury side is 1 day of service or 1 trial. And this is considered 1 trial. So for the purpose of that, it's 1 day. So in the scheme of things, we're still contained within that same period of time. But that actually works out well. And I do. Thank you very much for your patience. Thank you for your understanding. Thank you for your willingness to participate in the court processes. Because without you, the courts actually could not operate, whether it's a civil or a criminal matter.
Welcome back to 11 Alive's coverage. I'm Jeff Hudlinger along with attorney Bill McKinney, and Bill, I was reading one of Julie Wolf's tweets from inside the courtroom. 5 jurors now asleep, which maybe is a commentary on how things have been moving along at a snail's pace this afternoon. We started at 1:30. We've had a couple of breaks, but for the most part, an hour and a half into it, and nothing really has been decided as of yet, or so it would seem.
It appears to me they're still going back and forth with their selection or exclusion of those people they want to strike from the jury. That's what's going on now. The lady in purple is the clerk. She's waiting for them to finally finalize the alternates. That's the last step in the process. And then they're either going to do a silent strike and just announce their jury, or they're going to go back and forth as each juror stands up, and they will say either they accept them or they're respectfully excused. So we're just going to have to see what the judge does at this point.
The judge has been talking almost nonstop to the jurors as this sort of bantering has been going back and forth, everything from talking about coffee to serving animal crackers to put away your newspapers, don't consume anything. Fire marshals have come in to make sure that there are not too many people in the courtroom. A-OK is the word from them on that front, but it has been sort of a courtroom of intrigue in that both sides have been busily working and the judge has been working in a different way.
You know, the judge wants to be out while this jury selection is taking place. He didn't go back into chambers. It's commendable. Some judges will, and then once it's all done, they'll have the judge come back out. He stayed. But I think what he did is he's just explaining what the jury's responsibilities are. He took the time to do that while these attorneys were picking the jury. I think that's what he was doing, and he did it well.
Is there any scenario where a jury is not picked today? I mean, do you see any way that maybe this is not accomplished and it has to be carried into Friday?
I don't see it unless there's what's called a Batson challenge, and that is if one side or the other feels that the strikes are racially biased in one way, they will hold the jury, and then they will require the attorney to establish a sufficiently neutral reason why he struck certain jurors. I don't see that happening, but that's always a possibility.
The issue of race has come up in the form of the Sneiderman Trayvon Martin trial, but I think it has been more of a kind of roundabout way, talking about the system isn't perfect and that sometimes justice can slip through. That has come from some African American jurors who felt that there was unfairness and bias there that has sort of resonated in this courtroom, and from all probably practical applications all across America. It's been in a lot of courtrooms this week as a subject of discussion between attorneys, judges, and jurors. But as far as an issue of race in terms of selecting a jury at this point, that seemingly would not be part of this mix.
It should not be at all, because obviously we have a Caucasian defendant. The person who was killed obviously was Caucasian, so it should not come up. But Batson can also be used not only for race; it can be used for if you exclude all the women. If you target a significant member of the panel based on race, that's improper, or sexual orientation.
All right, here we go again, once again in front of Judge Adams, the defense making their way in front of him, and here comes the district attorney and his team as well.
You know, what sometimes happens is that during the selection process, sometimes the defendant or prosecutor is going to believe that the judge excluded somebody. So your group of the finalists of the jury panel may not match what your opposing counsel has. So you want to get together with the judge to make sure you're working with the same prospective jurors to exclude. Otherwise, you make an error, and you may think someone has been excluded, and they haven't been. So a lot of this, I think, is verifying not only the process, but that we have the same group of jurors we're selecting from. We have the same alternates we have to choose from. And that, unless there's some objection now as to maybe someone forgot to bring a motion for excluding a juror for cause, that would be the only thing I can see that's going on at this point.
So while both sides have been going back and forth on trying to select a jury, and the judge has been involved with the prospective jurors, sort of giving them instructions, large and small, the judge then jumps into the middle right now to try and be an arbiter between the two sides. Is that what the role that he is playing right now?
It's not so much as an arbiter, but basically letting both sides know who the jury panel is, who your alternates will be in terms of selection process, and to go forward.
All right, back into the courtroom now.
Completing the process, completing the questionnaire. I was just looking back over, it was about 20 plus pages, and that was a lot of information for the lawyers to digest over this period of time. Again, I do want to thank lawyers for moving through this process in a very, as far as I'm concerned, expeditious way. The next phase of the process, I will tell the clerk to identify those individuals by numbers, and she will give you certain instructions and follow those instructions, and I will give you additional information and instructions at the conclusion of hearing from Jay. All right? You may proceed, Jay, with jury management.
For those of you seated in the box, when I call your number, if you would, remain seated. If I do not call your number, please stand in the back of the courtroom.
And you will only be standing until we can get seats in the gallery. But Mr. Deputy, the door's open, the door's open, courtroom's open. You may continue.
Juror number 5, juror number 14, juror number 17, and juror number 28. Those jurors, please remain seated. The others that I did not call, if you would stand in the back of the courtroom.
So remaining should be 5, 14, 17, and 28. And let them just stand at the back because I don't have seats right now. You cannot leave right now, just stand. And when seats become available, you may be seated at that.
Juror
Wait
number,
1 second, come on up to it. Come up 29, I just want to make sure we're moving in order.
juror number 31.
Come on up, 31, please.
Juror
5-0. You can sit in any order. Just come on in and have a seat in the jury box.
Juror number 52.
52, come on up.
Juror number 57.
Thank you, come on up. Thank you for your patience, thank you for your understanding.
Juror number 61.
Thank you for your patience, come on up.
Juror number 66.
Come on up.
And juror number 72.
And those remaining jurors, you can just have a seat in those vacant seats for right now. Just got a few more things. Thank you for your patience, everyone. There should be enough seats for everyone. And if you could still have those numbers very visible, because I'm gonna have the lawyers make sure that the individual, just stay on if you don't mind. Lawyers, if you can look in the jury box and make sure, I can't see your number, young lady. It's just that we're tracking by numbers. I know your name, but lawyers, if you could, look in the jury box and make sure those individuals who are currently seated in the jury box are consistent with your notes and your decision. You from state?
Yes, sir.
One in defense.
Yes, sir.
All right. All right, ladies and gentlemen, in the jury box, you're the ones who have actually been selected as the jury at this point in time. I know you've been sitting for some time, so I'm gonna let you take a brief break in the jury room where there's restrooms, and I will bring you back out and give you some additional instructions, okay? You can go ahead and remove those numbers as you go through. The deputy's gonna show you where, and Jay will show you where the restrooms are. But you're on the jury, when you follow the instructions with Jay, please, and I'll give you some additional instructions. Also, go ahead and give the deputy your cell phone. You might want to get used to that process, because you can't have cell phones, laptops, iPads, any type of communication device there in the jury room. So, go ahead and follow Jay at this point in time. Go into the jury room. You tell the numbers. You have the deputy, my deputy, cell phones, iPads, any type of device that you have for communication, put it in the off position. It's going to be returned to you, but we're still going to do every day. Cell phone, and if you could put them in the off position, iPad, any type of communication device. And there is men and ladies restrooms there available. There's water in there. There will be water in there for right now, but just have a few more things we're gonna do together. Thank you very much for your patience and your understanding. All right, lawyers, you may be seated momentarily. Jay, no, that has to stay. All right, ladies and gentlemen, those individuals who are remaining, you can go ahead and remove your numbers and your blue identification card. This will conclude your service on this term with the jury set. And I'm going to ask Jay to come and collect those badges from you at this point in time. And again, on behalf of the Superior Court, thank you very much for your patience. Thank you for your understanding. Have a wonderful day. Enjoy the ride home. Bye. Lawyers, what we're going to do, and I know we have to go this before the record before we conclude, we're going to take a 5-minute break. Is 5 minutes enough, lawyers?
Yes, sir.
Of course, we'll go back on the record.
Yes, sir.
And then we'll go back on the record and conclude for today. Who's my deputy? It'll be 5 minutes. All rise.